My ladies and my lords, can I, in the interest of saving time on this point, the implied overruled point, take my ladies and my lords to MS 2849, which is in our case, and pick up from there what we say in relation to Michael, Mitchell and Smith, and the why we say they haven't impliedly overruled Dean's Berkshire, and indeed what is said in relation to Young and Bristol Aeroplane, rather than go through those cases, because I don't think time will permit that, and I hope we've set out our arguments in respect of that, because I want to take my ladies and my lords to the facts quite briefly, just to show how those fit into this case and how they were really very much skimmed over by the Court of Appeal. So from 2849, I should correct in paragraph 410, it's paragraph 126, not paragraph 26 of Lord Toulson's speech, and I'm sorry about that. That then deals with the passages in Michael and Mitchell, and the reference in Mitchell to Lord Hope's development of the Human Rights Act cases. We do point out that that is a separate section in the speech which is dealing with a freestanding Human Rights Act, and we say that was a misunderstanding in the Court of Appeal, that was dealing with the development of the common law. But I hope those arguments are all set out in the case. Unless there's anything in that section I can assist with, I was then going to turn to why this case does fit within the D&E Berkshire criteria, rather than subject, of course, to what the findings at trial are, rather than being a case, as the Court of Appeal described, being shoehorned into a children's case from a housing case. We say that the starting point is, were these vulnerable children at risk, and were these children that social services had an ongoing and active involvement with, so as to make them professionals dealing with this family. Firstly, can I go to the facts and issues, and then I'm going to take the court to some passages in the psychiatric report and Maria Ruger report. The statements of facts and issues is MS 2805, and the important points from our point of view are probably best picked up in the chronology, which is an annex starting at 2819. Just to get the dates, the 26th of May was when they were placed on the estate. CN was then 10, and GN was nearly 8 years of age at that stage. And then we see the behaviour that ensues. 10th of October on 2820, Mr. Cook is suggesting that he's going to keep an eye on things. I don't say that that's particularly important, but it's part of the background. There was a core assessment of CN's needs, 9th of November 2006. So there are assessments going on in relation to his needs. And we see where GN's behaviour becomes really worrying at 2822, 7th of September 2009, then age 11. GN threatened to jump out of a window after watching his mother being assaulted, threatened to drink bleach, tried to cut himself with a knife, left a suicide note, ran away from home, later returned to the police, who informed the defender, but the respondent, the details of that incident. And then from then on, there's increasing involvement of the local authority. 28th of September, management of the respondent's child health and disability team requested an assessment of GN's needs. I would suggest an experienced social worker is allocated if possible. Mum is very manipulative, frequently pulls in councillors and MPs to support her complaints. Historically, there's been difficulty assessing the impact, the real issues, antisocial behaviour issues, disabled son, unpicking where mum is behaving in a way that means her own needs and then evidencing it. One recent meeting felt strongly mum's mental health requires assessment.
Is it right to say there's no record of criticism of the mother in the earlier years, Miss Gumbel? Reading Mrs. Ruger's report as we have, it seems, at least to me, that the local authority were very impressed with the mother for the first years and thought she was doing a great job in awful circumstances, but that when she went in desperation to the media, the local authority bridled, and these criticisms of her start creeping in from time to time. Is that a fair summary?
That may well be right. Unfortunately, I'm not in a position really to answer that because I haven't seen the local authority records from
based
the
on Mrs.
time,
Ruger's report.
From Miss Ruger's report, which was based on the records given to her by mother. So
Yes.
and on, but that may well be right. But it doesn't mean that GN wasn't at particular risk once his mother was dragged into that, and she was unable to. On the face of it, this was a child who at one stage, as we'll see, was trying to kill himself twice a week and saying he couldn't get his mother's attention. Whether that's her fault, and I'm not suggesting it necessarily is something that the local authorities should at least have been looking into. It was something that needed attention because he was at very real risk.
Thank you. Well, you were at the 28th of September.
My lord, yes. Then 7th of October, another threat to kill himself. And then October, meeting took place. Respondents' community and social services teams noted the Child Health and Disability team had been involved since 2003, providing care, which comprised 91 hours of care. So that's showing the involvement. That will have been for CN, but there is then, from the 28th of September, obvious involvement in getting assessments in relation to GN. So we would say this is social services actively involved with the family and having an obligation to make it, to do, in a Bolam sense, what is necessary, and whether they did or not is the issue that would need to be tried. But they are involved as professionals with this family in quite a detailed way, certainly from 2009 onwards. Multidisciplinary meeting, which they described M as an unstable one. That may well have been unfair, and there's certainly suggestions in Ms. Ruger's report that it may have been unfair, but that was the impression they had. And the question then would be, if you've got a child who's trying to kill himself twice a week and you've got what you think is an unstable mother, shouldn't you be doing something, even if you're wrong about her being unstable? It's a situation of potential danger for the child, and your own impression of that should inform whether you do something about it. Then initial assessment completed, 30th of October, GN's then age 11. Her mother is unable to see her part in the conflict despite advice and guidance from community services. GN has found this experience to be traumatic, fears for his safety. Social worker, 24th of November, who has undertaken the assessment of GN's needs, reported to his manager DN's case required urgent transfer to the respondent's family support team for a core assessment to be undertaken. Mother finds it hard to meet his needs or to recognise why he is playing up and feeling resentful towards his sibling, does not seem to understand that a child of GN's age threatening to drink bleach is a serious matter. Over the page, allocated 1st of April, GN was allocated the same social worker as CN. So they've there got, we would say, if not before, and we would say it is well before, but here is a situation of a social worker specifically allocated to both children, and a professional relationship must then occur, we would say. Strategic manager for children's services, initial assessment of GN's needs has been flawed, further assessment planned, that's 14th of May. So again, ongoing active involvement. 15th of November 2010, GN threatened to jump out of a window following the death of the family dog. Following day, threatened to harm himself with a knife. Emma's asked the respondent to provide him with trauma counselling. And then 14th of June, GN found with a rope round his neck. And then June 11, a further child protection strategy meeting was held. GN's suicide attempts were discussed, decision taken to interview him at school away from his mother. So in more and more active involvement, and then still between June and December, it's not until December that there is then a move. Can I then briefly just turn to the report of Miss O'Neill, the psychiatrist, in relation to GN. That starts at MS 3046, at MS 3050, paragraph 37. From age 8 to 15 years, GN described wanting to commit suicide. I felt exhausted, worn out and a burden. My mindset was the world would be better off without me. Felt guilty his mum was worrying about him, believed that others disliked him, described becoming increasingly hopeless, feeling there was no solution, no way to end the harassment, described trying to hang himself on numerous occasions, believe at times he became very close as he was drifting in and out of consciousness. It's a miracle I'm still here. Tried to jump out of a window and injured his neck, tried to take tablets, would have self-harmed to try and numb the pain. Generally, GN described feeling increasingly depressed, loss of interest, loss of concentration, persistent intrusive memories about those events. And again, I know I've said this before, but none of this would come across to someone reading the judgment of the Court of Appeal in terms of the background to this case. And bottom of the page, admits to some ambivalence in the relationship with his mother, felt at the time she could have done something to help us more, felt angry she wouldn't listen to what I needed to say, felt at times, over the page 3052, she ignored me because she was so busy dealing with CN, angry that she didn't spend enough time with me, constantly writing letters and consumed with the legal battle. And then 56, after every incident of harassment, antisocial behaviour, GM would try to harm himself within days. Over a 2-year period, regularly try and kill himself 2 or 3 times a week. So that gives a flavour of what was happening to this child. Turning then to the report of Miss Ruger, which, of course, was written at a very early stage and was written on behalf of the earlier action, some of which is not pursued in terms of the mother's position, but it does set out the history, and it begins at MS 3066, and it's important at 3068 to see what Ms Ruger did have. I've not seen the defendant's records in respect of any of the 3 claimants. The papers provided by the mother contain copies of correspondence between herself and the defendant and documents she obtained under Freedom of Information, data protection and access to records requests, but the correspondence documents amount to only a small proportion of the correspondence. The documents to which I have had access are therefore nowhere near a complete record of the defendant's involvement with the claimants during the relevant period. So I think that's important background. And then in terms of what there's some stark contradictions in her report, just picking up some of them. Paragraph 585, MS 3098, it's documented that just 3 weeks later, on the 5th of February 2009, one of the agencies providing respite care to CN withdrew its staff because its risk assessment found that the family home to be at such a high risk of attack that the risks posed to staff attending the house could not be justified. So to not categorise this as a family in need and a vulnerable family does seem somewhat astounding that even care workers didn't feel safe attending the family. The core assessment, picking up what happened about that.
Sorry, could you just pause a moment? Where do they say they do not think the family is in need?
It's what I'm referring to is the Court of Appeal approach to this is a housing case. It's not a case relating to social services and duties to vulnerable children. It's shoehorned into a children case when it's really a housing case. Now, I wasn't referring to the local authority certainly did accept needs, and that's where we say that is the local authority's involvement and why their involvement is engaged. I'm sorry, that was. It's really to say in terms of the judgment of the Court of Appeal, it's not seen as a case involving vulnerable children and needs of children, but only antisocial behaviour and housing needs. In terms of the core assessment, MS 3119, the revised core assessment of GN's need was completed on the 17th of June 2011. GN has been a long-term victim of crime, as such as potentially vulnerable, among other things, to a psychological impact, including reactions of anxiety, fear, anger, shock, disbelief, and the social worker agreed with Dr. Dix a housing move was essential, concluded if nothing changes and if current progress is not sustained, it's likely GM will continue to have low self-esteem, bouts of despair and difficulty of making and sustaining positive relationships necessary for a successful and fulfilling life. Decision taken to undertake a Section 47 assessment is then in June 2011. The conclusion on which the allegation that if nothing else could be done, and it is only put in terms of as a last resort that the children should have been moved first, as it were, is from MS 3149, and the conclusions of Ms. Ruger. Paragraph C, negligently failed to protect CN and GN by moving them from the family home if the defendant was unable to provide the family with alternative or respite accommodation, then in my opinion it has a duty to provide both children with respite care in their own right, at least from September 2006, would have been consistent with its statutory duties and principles on which they are based, defendant to have ensured that the boys had frequent contact with their mother and that she continued to be involved in their care during periods of respite. And then it's likely the defendant would have had to provide the boys with accommodation on a full-time basis until the family were rehoused. On the basis of the current papers, which contain very little information about the impact of the harm on the boys, my preliminary view that this position would have been reached at the latest by mid-2008. Well, that's a preliminary expert's view, but it's a view which we would say must at least produce an argument that there were failures and things that could have been done. Whether there were in fact failures, what they could have done, how much help they in fact gave to the family are all, of course, matters for trial. And it may be that their files contain reasonable Bolam defence to the situation. But all we're here to say in this litigation is that this is a case about the plight of vulnerable children, the role of social services in preventing significant harm if you have a boy who is very seriously making suicide attempts whilst his plight is as it was. And to say that that is not something that engages social services' direct obligations as professionals is to move backwards into the world of Exon Bedfordshire, where social services only owe a duty to their own local authority and have the child is outside the ambit of their protection. And that's what we say is wrong about the Court of Appeal decision, that the law has moved on through the cases that I've been tempted to go through to the position in D and East Berkshire, which we say is right, if it is right, then this case must arguably come within that duty of care and ought to go to trial to determine that. I'm hoping to leave some time for Mr Fairgrave to deal with the comparative law. So unless there's any other points I can deal with, I'm afraid I've left some of it to the skeleton.
I'm afraid I'm still not quite clear how you put the link between the statement that you've just read out from this report, that the local authority should have removed the boys from the family home until they could all be rehoused together, speaking of respite and so on, and how they would actually have gone about it in law.
Well, the first thing would have been to ask the mother. And
is there any, did this social work witness see the mother?
Well, we've no idea of the contact with the mother.
No, this social work witness that you've been reading from, Miss Ruger.
I'm not sure that she did.
Okay.
Just take instructions on that. No, she didn't.
She didn't. Okay. So would it depend upon her consenting? Is that the legal route to the removal of the children?
Well, it's one route.
What are the others?
If she didn't consent, then the reasons for her not consenting might have needed to be investigated in order to see whether it was reasonable to seek some assistance from the court if she didn't consent.
What sort of assistance from the court?
Well, as to whether the children were at such risk of harm, if she didn't consent and if they were at as extreme risk as they appeared to be from suicide attempts that could have, not to put too fine a point on it, resulted in the death of one of them.
But it's not just risk.
A failure to protect.
It's not just risk, is it? It's to do with the care given to the child, or likely to be given to him, not being that which it would be reasonable to expect a parent to give to him.
Well, a child who, if it's right in the comments that we do have, that she wasn't taken seriously, a child drinking bleach, then the failure to protect would be an issue. And if she was campaigning at the expense of doing things for her child, who was, we would say, on the face of the documents and the details that we have, in very severe need of support and help and everything that she could possibly do to mitigate his suicide attempts. 2 suicide attempts over a period of 2 weeks for a mother who's putting his needs first would be an unusual situation if, as is said in the psychiatric report, he felt she was not paying him enough attention. You would have to examine whether there was an element of failing to protect and placing him at significant risk of harm. It may or may not be the case, but there is at least an argument that a mother who leaves a child in that position is failing to protect him from very significant harm. The harm may not have been instigated by her in the first place, but it doesn't mean a child who is ill and not properly looked after. There's also another reference to her not taking CN to the neurologist during this period and missing medical appointments. She was obviously doing that before. If she is so distracted by this campaign that she is no longer able to keep the good standard of mothering that she had before, and she has a very severely disabled child who has very high needs, and another child who is attempting to commit suicide, it may well be the point is reached where, on a short-term basis, she is unable to protect them, unable to meet their needs, and the threshold criteria are met with the provisos that obviously she will have a great deal of contact with them, and they are needing to be placed somewhere safe on a temporary basis. But those are all issues which there would need to be a great deal of further investigation as to what could be done. And I know that my own friend for the Air Centre is going to address the issues of what other steps could have been taken in terms of family law when addressing you for the interveners.
Would the boys have had a voice about whether they should be removed from their mother?
If they were seen to be of an age where they should...
Well, 2008 is what we've just been looking at.
Yes, I mean...
What was the evidence about
well, there was
their voice?
Well, there is, until GN is seen at school, it doesn't look as though they are being asked. But the subsequent psychiatric report suggests that GN felt that his mother wasn't paying enough attention to him, and that part of the psychiatric report's concern was that the mother was paying more attention to campaigning than to looking after his needs. She ignored him because she was so busy dealing with CN, angry she didn't spend enough time with me, constantly writing letters and consumed with the legal battle. That was...
Well, you've been up against the clock, and insofar as your references have been selective, you're not to be criticised for that, Miss Gumble.
My Lord, I'm sorry if there are various other references. It's obviously an ambivalent situation as far as he was concerned.
Yes.
And the fact that we don't know whether he was asked and what he would have said, I appreciate there's also admits some ambivalence in the relationship with his mother. Felt at times she could have done something more to help, but there's also a reference to him being very fond of her, and obviously there
Indeed.
There are references either way, and I'm sorry if they have been selective. And I'm not suggesting, and that's not the point of it is not that she was an obviously irresponsible mother. It was that a situation was reached where he was at risk because of the behaviour, and they needed to look into how could they reduce that risk, how could they look after him as they were involved in the care of both him and his brother. And that is, patently investigation at trial as to whether they did the right or the wrong things and what else they should have done. But I hope my ladies and my lords will get further help on what could have been done in family law terms from the interveners.
Can I ask you, again, no doubt because of pressure of time, you haven't really attempted to explain how this case, or for that matter D, can be understood in terms of the analytical framework established in Michael and Robinson for dealing with negligence liabilities of public authorities. That you have produced an article at MS 3252 by Dr. Tafaris, which does address this. Do you want to adopt the argument set out there?
I hope Mr. Fairgrieve will deal with the academic literature perhaps in a little bit more detail if I give him a short slot.
Thank you.
Is there anything else that... I'm sorry.
Well, there's probably a great deal more, Ms. Gumble, but you can trust us that we will actually read things and reflect upon them,
of course,
and make such inquiries as we make. But the point I take from your answers is that our questions are actually revealing why this should not have been a strikeout.
Indeed. I think that's exactly what I say.
May or may not be correct. Not saying anything.
It's exactly what I say.
Yes. You've got 1/4 hour, Mr. Fairgrieve.
Sorry, yeah.
Lords and ladies, I'll be succinct. I've been asked to address you on 2 points, really. One is the comparative law backdrop, and the other is the academic authorities, which have just been referred to. You will have seen that we've produced, as an appendix to our case, a short comparative law study, which you'll find just after our case, written case MS 2866. So I don't propose, and given the constraints and time, that's reiterated, I don't propose to go through that in great detail. But what I do propose to do really is just to make 4 propositions, which we say are made out by the comparative law backdrop, and gather up some of the arguments from the very important, interesting academic writings as well. My first proposition is the following, that comparative law is particularly relevant to this area of the law and particularly to this case. That's my first proposition. Second proposition is that that comparative law shows that the Court of Appeal's decision in D&E Berkshire was actually not an isolated decision. it was actually very much within the norm in terms of the foreign law and common law sources. My third proposition is that, in fact, actually the Court of Appeal in CN, and in this case, is actually a case which is a decision which is at odds with international standards. And my fourth proposition is, and which is related to what I just said for the third proposition, my fourth proposition is that the decision in the Court of Appeal in this case has generated considerable disquiet in the academic literature. And Lord Reid has just referred to that a minute ago, and I'll try and build up upon that. So my first point, comparative law is particularly relevant to this case. I don't propose to say very much on that point, because we've seen already that in the relevant cases, comparative law has been drawn upon. One example is the Michael case, where Lord Toulson, in his judgment, undertakes a survey of the relevant decisions. So in relation to public authority liability, comparative law has, I think, been useful for the courts. And of course, particularly in this area.
Take it for granted that we are interested in comparative law. You don't.
Proposition 2, thank you. These are gained a bit of time. Proposition 2, that D in East Berkshire was not an isolated decision, and you see, Lords and Ladies, from our comparative law study that jurisdictions such as New Zealand, which we've heard about already, and there's been discussion of that, Canada and Australia have shown that a duty is owed to children in these cases, and particularly in failure to remove cases. And that's particularly picked up in an excellent academic text by Laura Hayano and Catherine Keenan, Child Abuse, Law and Policy, which is in Authorities Volume 8. There's an excerpt in Authorities Volume 8, tab 78, which looks also at the comparative backdrop. Maybe just say a word, if I may, about the New Zealand cases. I do that because they have been mentioned already as being relevant. And I think it was Lord Wilson who made reference to the Prince case, which I think was probably the starting point of the New Zealand case law in this area. Then subsequently, of course, there was the Attorney General of New Zealand, which we've already seen. But Prince, I think, is interesting, and it's may perhaps invite you to take up. It's in Authorities Volume 7, tab 68. Attorney General and Prince, it's a Court of Appeal decision, and this relates to a claim in relation to an adoption of a young man. There are various claims made in relation to the actual adoption process.
MS number?
Sorry, this is MS 2314.
Thank you.
Various allegations made in relation to the adoption process, where I don't propose to say anything about because it's very different to what we're looking at today. But there is an allegation made in relation to the failure of the authorities in that case to investigate an allegation of abuse. It was said that the young man had been effectively abandoned, neglected by his adopted parents, and a relation had made a complaint to the authorities. And so the claim was made on behalf of the child that there was a duty of care in relation to that, and that failure to investigate that abuse and neglect allegation gave rise to a breach of that duty of care. If I take you to MS 2333, which is where it's set out what the actual complaint entails. Part way down, line 16 or 17, using the numbers on the side, the 1983 complaint, a duty of care, is the heading. Line 16, 17, 18. The focus in the present inquiry is necessarily on whether the department owed a duty of care to Mr. Prince when responding or failing to respond to the complaint alleged to have been made in 1983. Then there's a discussion about in relation to the statutory background, which it was admitted is different. And then a bit further down the page at line 40-41, reference to the strikeout nature of the in this case, and that the conclusion that it was inappropriate to strike out. There is no basis for determining strikeout on the footing that is necessarily a pure omissions case in this case, or that the Director General or social worker exercise any particular judgment. So that's the strikeout context. Over the page onto page 282, which is MS 2334, there is a recognition about halfway down that page, line 21, 22, 23, the importance of the professional relationship. This I think relates to what we said earlier today, which is that the discharge of the particular function calls for the exercise of special social work skills and responsibilities. There is a professional relationship between social worker and client, child or young person. And that is picked up in a number of areas of the judgment, and also later in the Privy Council in B and Attorney General as well. Over the page onto page 283 is when the discussion of the policy concerns are raised. 283 and 284, this is MS 2335 and MS 2336. And there's a very important section, which is about halfway down page 284 on MS 2336, where the reference to the policy concerns in the Exton Bedfordshire case are raised. And the judges take a very different approach to that. The judges say that this is the section starting on line 35. There are other policy considerations to be considered. The difficult and delicate nature of the social worker's task. The court says that is not of a nature to reject a duty of care at line 45. And then we find at the bottom of the page a reference to the so-called chill effect, a more cautious and defensive approach to duties. And then over the page on 285, other canvassing of other policy concerns, and line 17 or 18 of that next page, 285. For these reasons, on the pleadings they stand, we would not strike out the cause of action in negligence. And that excerpt of Prince is cited in many of the following cases as a shift away from the Exton Bedfordshire policy concerns, which had been attractive to the House of Lords at that time, and which had not the same force in this jurisdiction. And of course, they were referred to in the Court of Appeal in East Berkshire, and that section I've just read out to you was referred to as being important in the sense that it illustrated a shifting away from the policy concerns as the law moved on, and reinforced by the context in other jurisdictions as well. So that is all I wanted to draw from the Attorney General and Prince case. I don't think we need to go to the Privy Council case in B and Attorney General, because we've referred to that already. As Lord Wilson correctly said, it was in essence an extension of what was found in Prince, because B and Attorney General was a failure to investigate properly. Not a failure to investigate, but it was actually alleged negligence in the way in which the actual investigation had occurred. And there had been an argument as to whether that was different from the Prince case. The New Zealand Court of Appeal had found that was actually different, and the Privy Council took a different view, and as we saw earlier on, adopted the distinction between a duty being owed to the child, but not to the parent. And as was said, I think it's important to note the panel in that case, Lord Nichols, Lord Hutton, Lord Hobhouse, Roger and Walker, many of which had been involved in the cases shifting away from Exon Bedfordshire, particularly Lord Hutton, who had given the judgment in Barrett and Enfield, had been also on the panel, I think, in Phelps and Hillingdon, the educational case, and Lord Nichols as well. So what one sees there, of course, it's a foreign jurisdiction, it's a Privy Council decision about the law of New Zealand, but it was the panel's made up of English judges who had themselves been involved in the key cases and seeing that, as was described earlier, moving on of the law from the restrictive process in Exon Bedfordshire. I have 2 more minutes. What I propose to do is I refer to, I think the Canadian case law is interesting and Australian case law is interesting, and that is all contained and summarised in our case. In the comparative law study after the case. Canada is pages MS 2868 to 2869, the AJ and Kearney estate case where a duty of care was found in relation to a failure to remove case. And then there is also the Australian case law as well. My third proposition was that CN and Poole is itself a case which is at odds with international standards. I can happily, I think, probably let the Intervene the Air Centre deal with that. They cover that in great detail in their case and explain how the international law context is relevant, and I'll leave that to them to deal with. I would just flag up one point, which is the US case, which we refer to in our comparative law study, MS 2874 to 2876. It's an iconic US case, actually, called the Tishaney and Winnebago County case. A very sad case involving the failure of social services to remove a child, Joshua. It's called the Joshua case often in the US. And the US Supreme Court held that did not constitute a violation of the relevant provisions, but those provisions were constitutional provisions in relation to the due process safeguards under the US Constitution. And in fact, what the court holds, although that was not breached, at a state level, tort law could provide a potential remedy. And that is exactly what has occurred. I can refer you to an academic article we've produced, Michelle Miller's article, which is in Authorities Volume 8, Tab 82, where the US academic refers to what's known as a state-created danger theory, whereby when a public body can be liable in tort law, not under the Constitution, but under tort law, for placing a person in a position of danger and then failing to actually intervene. I think there are some interesting parallels. We know here that there was a recognition in the CN case that the environment where the family were placed was not ideal, to put it. There's a knowledge on the part of the local authority of that the direct neighbours were a problem family. So I think that exception to the it shows that even in the US, which I think one is often seen as being one of the most restrictive jurisdictions in relation to governmental liability, there are exceptions allowed under tort law and not the sort of rather stark position that we've seen in the Court of Appeal in this case. My final point, I've gone over.
Well, you're out of time, so make it.
But I can make it very succinctly because I can refer you to my final point was the academic disquiet. Yeah. And I think what I can do is just invite you to look to the case notes on the Court of Appeal decision in this case. Professor Howarth, Cambridge tort lawyer who's very, very critical of the reasoning and result in this decision. Authorities, Volume 8, tab 77. Dr. Tafaris's article, again on this, on the decision in the Court of Appeal, very critical of the decision, that is in, that's under, actually, it's not in the volume, it's not in volume 8, it's under
the core volume. It's the end of the core volume. In particular, in relation to that article, do you have anything to say about his analysis of how he ties in his reasoning to the more modern approach to
the matrix,
liability?
Matrix of the emissions, yeah.
Yes.
But he's very critical of the adoption of, by the Court of Appeal, of the policy concerns, as opposed to, so that's the first point, and we don't have that. The second point, which I think you're referring to, is how does the circumstances of what we're saying fit into the emissions rule? And I think the response there is given really twofold. One is that he refers to the creation of danger argument, I've just referred to a minute ago, that the fact that it's difficult to conceive of something being an emission.
You could take it, I've read the article, it's the creation of danger and it's the assumption of responsibility.
Or we could. I mean, I think we'd prefer to see it as a special relationship, as was explained earlier on, and I've just made good, I think, for some of the comparative materials, a relationship between a vulnerable child dependent upon, entirely dependent upon the act of the protection of a professional person, a social worker, as we've seen from the cases, that being a special relationship, maybe not any, different terminologies used, but that creates a special relationship, which means that then that takes it out of the ordinary matrix, as it's such, of emissions and liability. I think that's very important for this case, and it's borne out by crucially by the cases we saw earlier on, as recognising that is the status of a social worker.
So you are commending the article to us then?
I am absolutely commending the article to you, and I think it helps to explain how this area of the law fits into that overall, and why also the emissions principle itself, when one is a child, some of the theoretical arguments don't have maybe the same strength that they would do in relation to an adult, etc., who maybe is expected to be able to, individual responsibility, etc., where a vulnerable child would maybe not be expected to be able to look after themselves in that way, that some of the cases. That's
perhaps where status comes in. For example, parental status, and in this case, the status of a person appointed for the purpose of looking after the care of or ensuring care is taken to ensure a child's being properly looked after.
Absolutely.
Well, we better stop you there, because you've eaten into the Air Centre's time, I'm afraid.
Many apologies.
Thank you very much.
Thank you.
My ladies, my lords, I, together with Mr. Philip Havers, Queen's Counsel, and Miss Hannah Noyce, represent the Air Centre, instructed by Miss Nuala Mole, who has instructed a team of lawyers at Allen and Overy, to whom we are eternally grateful for the immeasurable assistance they have provided to us in preparing for this hearing. This court is well aware as to what the Air Centre is, but for the benefit of others, the Air Centre is an independent, non-governmental organisation which is a charity and a law centre. It has a long-standing commitment to acting in litigation before domestic and international courts, and often acts as a representative, an intervener, or as an expert third party, sharing its expertise on procedural and substantive law. It has appeared in over 100 cases since the organisation was founded, both before this court and before the Strasbourg court. It was, of course, a party in many of the Strasbourg cases which have underpinned the development of English law in the area under consideration in this appeal. There are 3 other interveners who have filed written cases in this appeal: the Coram Children's Legal Centre, Article 39, and the Care Leavers Association, the latter 2 organisations having made common cause in joint submissions. I also believe that the Equality and Human Rights Commission has successfully applied to intervene in the
They were given
proceedings.
permission, but they've decided that everything has been said that could possibly be said, and so they don't need to use
Quite
it.
so, my lady. The interveners...
We didn't particularly want everybody to appear to be ganging up on the local authority.
We understand that. The interveners have filed a separate core bundle and a separate supplementary bundle of authorities, and there is a supplementary digital memory stick. I will endeavour to provide references by tab number and supplementary memory stick references, SMS, together with some references which appear on the main memory stick, MS. The written submissions themselves, provided by the interveners, appear in the bundles as follows. In the Air Centre, in the interveners core bundle, tab 7, SMS 1280. The Coram Children's Legal Centre, submissions prepared by Deirdre...
I think you can assume that we've read them all.
I'm most grateful. I think the court is aware that all of the lawyers acting for the interveners are acting pro bono, and that by order made by this court on the 26th of June, I, who represent the Air Centre, have been asked to make oral submissions on behalf of all of the interveners. In fact, the CCLC have indicated in terms that their written submissions speak for themselves, and they have not asked me to amplify their submissions orally today, and I will not endeavour to do so. As to the joint intervention by Article 39 and the Care Leavers Association, we have agreed between us that I will address you briefly today and bring to your attention matters contained within their written submissions which they wish to highlight to the court.
Well, I thought the permission was given for written submissions only in those cases.
Well, yes, but permission was given for oral submissions by the Air Centre, which would incorporate any additional points. That was specific.
I see. Okay.
It goes without
Again,
saying...
it was to avoid there being too many people on their feet
Yes.
attacking the local authority.
It goes without saying that all of the interveners are extremely grateful for the opportunity
You don't need to waste time saying that.
Very well.
Get on with your main points, which will be
please
of
do.
much more assistance to us.
From the scope of the submissions made, the interveners are principally concerned with the broad issues of public importance arising in this appeal, and in particular whether there still exists a duty of care owed at common law by local authority social workers to children in relation to whom they are exercising their statutory functions under the Children Act 1989, so as to give rise to an action for damages for negligent discharge of those functions. I propose to summarise the submissions of the Air Centre first, and then to move on briefly to the submissions of Article 39 and the Care Leavers Association. Referring to the Air Centre submissions, and by way of overview, the Air Centre advances submissions which focus on the issue as to whether D and East Berkshire was correctly decided. We submit that it was, in addition to all the reasons advanced by the appellants, submit that the international obligations of the United Kingdom require the courts of England and Wales to maintain the existence of a duty of care owed by a local authority to those children in relation to whom it is exercising its statutory social services functions. If this analysis is correct, it will mean that a child may bring civil proceedings in negligence, as well as under the Human Rights Act, and may claim damages assessed on conventional common law principles, and will thereby be provided with an effective remedy. In our written case, we sought to review the Strasbourg jurisprudence and international law instruments relevant to the issue as to whether the English law should continue to recognise the existence of a duty of care owed by a local authority to children for whom it is responsible. In our written submissions between paragraphs 22 and 31, we make reference to the obligations of the United Kingdom as a party to the United Nations Convention on the Rights of the Child, and in particular, at paragraph 24 of our submissions, we refer to the best interest principle at Article 3.1, and I quote, "In all actions concerning children, whether undertaken by public or private social welfare institutions, courts of law, administrative authorities, or legislative bodies, the best interests of the child shall be a primary consideration." Those provisions are set out at tab 111, SMS 668. Secondly, we refer to the voice of the child provisions in Article 12, between paragraphs 28 and 29. And thirdly, we refer at paragraph 30 to the obligation upon states under Article 19 to take a full range of measures to protect the child from all forms of physical and mental violence and abuse is a widely defined term within that provision. Turning now to the European Convention on Human Rights, in summarising the position, we submit that so far as children are concerned, it was clearly established long ago by the Strasbourg Court that in interpreting the Convention, special status is afforded by the Court in its jurisprudence to the rights of children. Our analysis on this appears between paragraphs 55 and 59 of our submissions. That court has also identified a number of material obligations cast upon states, and we highlight the principal ones as follows. Firstly, states are positively obliged to take steps and measures to protect persons from ill treatment by third parties. In other words, to prevent an arguable violation of Article 3. See paragraph 6 of our submissions, where we cite the decision in A and the UK, and in particular the court's conclusions at paragraph 22 of that report, tab 114 SMS 788. Secondly, and more particularly, states are required to take positive steps and measures to prevent ill treatment to children from harm threatened by third parties. We set that out between paragraphs 7 and 10 of our submissions. Thirdly, states are under a positive procedural obligation to conduct an effective investigation when a child raises an arguable claim of ill treatment under Article 3. See our analysis at paragraph 15 onwards. Fourthly, ill treatment has been held to include not just inflicted physical harm, but also exposure to domestic violence and campaigns of sustained physical and psychological harassment conducted against the vulnerable, and in particular towards children. We analyse that at paragraph 10, where amongst other cases we make reference to the case of Dordovic and Croatia, which is in volume 6, tab 59, MS 1869. Fifthly, states are also required to discharge their domestic legal responsibilities to children in a manner which does not violate their rights under Article 8. That is where the conduct of the authority arguably amounts to a violation of a child's right to respect for his or her family life, or private and family life, which is now well understood to include a person's, and I quote, physical and psychological integrity, close quotes. We deal with that between paragraphs 11 and 14 of our written submissions, and we make reference again in particular to the conclusions of the court in Dordovic and Croatia at MS 1912. That's volume 6, tab 59. Sixthly, importantly, for the purposes of this appeal, where there is an arguable breach of a convention right, contracting states are required under Article 13 to provide an effective domestic remedy. The remedy must be effective in practice as well as law. We analyse this between paragraphs 19 and 21. And finally, in its decisions which postdate the decision of the Court of Appeal in D and East Berkshire, the Strasbourg Court has confirmed that, when determining allegations about suspected child abuse which involved an alleged breach of Article 3 and or Article 8, the Court will necessarily have to consider the conduct of individuals involved, and in so doing will apply a test which approximates to that which applies to a breach of duty at common law. We analyse that between paragraphs 43 and 54 of our submissions, where we make reference in particular to the decision in RK and AK and the UK, which was a claim made by two of the parents in the D litigation, and in particular make reference to the passage in the judgment at paragraph 44, which is at SMS 1080, that's tab 123. Secondly, in that connection, we refer to the decision in AD and OD and the UK. We analyse that between paragraphs 49 and 51 and cite the passage at paragraph 103, where the court held that the right of a child to bring a claim in negligence and to appeal against an unfavourable decision would normally constitute an effective domestic remedy. See MS 1867. Furthermore, we make the submission that there is likely to be a significant factual overlap between arguable actionable breaches of duty at common law, arising whether by commission or omission, and arguable violations of Article 3 and Article 8. In nearly all cases, they will require the court to survey the same factual landscape, to consider the conduct of the individuals involved, and to apply an equivalent test. This confirms that the policy considerations which led the court in X and Bedfordshire to conclude that no duty should be recognised are no longer applicable. We therefore submit that the analysis of the Court of Appeal in D and East Berkshire, and in particular that analysis between paragraphs 80 to 85, was correct. The reference for that is MS 248. Finally, we make the submission that an effective remedy in this context should include the right of a child to seek damages against the local authority for the negligent performance of its statutory functions, and that for a variety of reasons, the remedy offered by the right to seek damages for breaches of convention rights under Section 7 of the Human Rights Act is an insufficient and ineffective one. But we focus on just 3 areas. So in the time available today, I will aim to concentrate on 3 matters. Firstly, to draw the Court's attention to some of the more important decisions made in Strasbourg. Secondly, to address the question as to whether the notional right to claim damages under Section 7 of the Human Rights Act constitutes an effective remedy for a child. And thirdly, as a matter relevant to the issue of causation, we simply wish to draw the Court's attention to the fact that in assessing the conduct of social services in discharging its duties to a child at risk of harm, a social worker is not faced with a simple binary choice between doing nothing and applying to the court for removal under Section 31 of the Children Act, and that there are a number of other practical measures which would need to be considered before an application for removal could be contemplated. Dealing firstly with the convention cases, we only briefly mention Z in the UK and TP and KM in the UK because those cases predate and were fully analysed by Lord Phillips in the Court of Appeal in D and East Berkshire, between paragraphs 57 and 65. We support the analysis of those cases and his central conclusion, stated at paragraph 81, that as a result of the implementation of the Human Rights Act and the right to claim damages for convention violations, the reasons of policy that led the House of Lords in X and Bedfordshire to hold that there is no duty of care cease to apply. In brief summary only, therefore, in Z in the UK, the Court addressed the claim brought by the claimants in the X and Bedfordshire litigation, including those of the children, for the admitted violation of Article 3, arising from the failure of social services to remove 4 children from an abusive household, and who, as a consequence, suffered several years of abuse. One of the vital issues before the Strasbourg Court was whether there was an obligation on the part of the English legal authorities to provide a remedy by way of monetary compensation in the form of damages. The Court stressed that contracting states were under a positive duty not only to pass criminal laws outlawing treatment falling within Article 3, but also to take measures providing, and I quote, effective protection and in particular of children and other vulnerable persons, close quote. In that case, the Commission had reported that there was a positive obligation on the government to protect children from treatment contrary to that provision. The authorities had been aware of the serious ill treatment and neglect suffered by the 4 children over a period of years at the hands of their parents, and failed, despite the means reasonably available to them, to take any effective steps to bring that to an end. The Court accepted that view, and we refer to tab 20, MS 893. As to the requirement for a remedy for damage caused by conduct which would amount to a breach of convention rights, the Court expressed itself in the following terms at paragraph 109, and I quote, "Where alleged failure by the authorities to protect persons from the acts of others is concerned, there should be available to the victim or the victim's family a mechanism for establishing any liability of state officials or bodies for acts or omissions involving the breach of their rights under the Convention. Furthermore," close quotes, Furthermore, in the case of a breach of Articles 2 and 3 of the Convention, which rank as the most fundamental provisions of the Convention, compensation for the non-pecuniary damage flowing from the breach should in principle be part of the range of remedies available. Volume 3, tab 20, MS 903. TP and KM and the UK concerned the claim brought by the child in the Newham case, where a child had been removed from the care of her mother after an allegation of sexual abuse, which was initially and mistakenly directed at the mother's partner, but later found to be directed at someone else. The child's claim against social services was struck out, a position upheld by the House of Lords, holding that there was no duty of care. However, in the European Court, it was asserted on behalf of the child applicant that to deny the existence of a common law duty of care amounted to a violation of her Article 13 right to be provided with an effective remedy. The Court accepted that submission and held that the remedies posited as sufficient by the government of applying to the Ombudsman or to the Secretary of State were not adequate remedies and did not provide the applicants with any enforceable right of compensation for their non-pecuniary losses, such as the psychiatric damage alleged to have been suffered. And we refer in particular to the passage at paragraph 109, Volume 11, Tab 125, MS 1158. MAK and RK in the UK was an application made by the claimants in the D litigation after the case had been considered by the House of Lords. The applicants were one of the wrongly accused parents and his daughter. They alleged breaches of their rights under Article 8 on grounds that the hospital in which the daughter was being treated had taken the decision to prevent the father from visiting her due to suspected child abuse, and further that tests had been carried out on the child without parental consent. There were also claims of a violation of the father's rights under Article 3 and of the child's rights under Article 6 in relation to the withdrawal of her legal aid funding, both of which were dismissed. The claims under Article 8, however, succeeded, and the court went on to find a breach of the father's rights under Article 13. That's MS 2005. As was noted by the Court of Appeal in D with regard to the earlier case of TP and KM and the UK, the test applied by the European Court in both cases I have just cited closely approximates to that which would be appropriate when considering whether there had been a breach of duty of care at common law. In TP and KM, at paragraph 74, SMS 1150, the court considered whether the actions taken by the relevant public authority were supported by relevant and sufficient reasons, taking into account the state of knowledge and the actions of individuals involved. That process necessarily involves an examination of the conduct of those involved in taking the relevant decisions, as was noted by the Court of Appeal in D, paragraph 80. The detailed consideration of the conduct of the doctor in MAK and RK above provides a particularly clear example of such an assessment. The final case is A and OD and the UK, Volume 6, Tab 58, MS 1848. This was another case involving allegations of child abuse which turned out to be unfounded. The court carried out a detailed examination of the conduct of individual doctors and social workers in coming to the conclusion that there had been a breach of the applicant's Article 8 rights. Once again, as identified by the Court of Appeal in Dean East Berkshire, the issues raised by the European Court were very similar to those which would fall to be considered in an equivalent claim in negligence. In having regard to the availability of an effective remedy under Article 13, the court found that there had been a violation of the mother's rights under Article 13, in that she had been denied the right to bring a civil claim in negligence. However, there had been no violation of the child's rights, and at paragraph 103, the court explained why. I quote, "The court considers that the right to bring a claim in negligence and to appeal against an unfavourable decision would normally constitute an effective domestic remedy." Tab 58, MS 1867. Well, the reason for that, of course, was because in 2010, when this case was considered, it was considered to have been settled beyond doubt by Dean East Berkshire that the relevant duty of care existed in English law. In summary, therefore, and to conclude on this point, these and other cases referred to in the written argument form part of the same line of Strasbourg case law which can be traced back through the cases referred to by the Court of Appeal in D. They raise the same issues, apply the same test, involve the same scrutiny of individual conduct as those early decisions. The approach of the European Court in relation to the violation of the Convention rights of children is now well established and has been applied in a long line of clear and constant jurisprudence, both predating and postdating Dean East Berkshire. We submit, therefore, that on the basis of that jurisprudence, the Court of Appeal indeed was right to conclude that insofar as the position of children is concerned, the decision in X and Bedfordshire cannot survive the Human Rights Act. We submit that this conclusion is confirmed beyond doubt by the above decisions, and accordingly there is no sound reason arising from principle or policy to suggest that this settled approach did not or should not survive the decisions of this court in Mitchell and or Michael. I turn very briefly to the second issue, namely whether the right to claim damages for breach of convention rights under Section 7 of the Human Rights Act is an effective remedy. It will be suggested by the respondent that the convention jurisprudence we have cited, in which Article 13 was found to have been breached, were all cases where the claimants did not have available to them the right to claim damages under the Human Rights Act, that statute not then being in force. Although this is true, we submit that the remedy offered by Section 7 of the Human Rights Act is arguably not an effective remedy for the purposes of Article 13, and not an answer to the question as to how children should be compensated for conduct which amounts to a violation of their convention rights. We refer to our analysis in our document between paragraphs 66 and 79. The text of Section 7 of the Human Rights Act is in Volume 1, Tab 2, MS 46. We submit that to comply with Article 13, the competent domestic authorities must supply a remedy which is effective both in practice as well as in law, and refer to the passages at paragraphs 108 and 109 of Z in the UK, MS 903. In submitting that Section 7 does not provide an effective remedy, we would point to the following features. Firstly, as a matter of law, damages are not an automatic remedy even upon proof of loss. The terms of Section 8 of the Human Rights Act, which are set out at MS 48, provide as follows. Section 8.3 provides that an award of damages must be necessary to afford just satisfaction to the claimant, having regard to any other relief or remedy granted. Secondly, there is a strict time limit of 12 months running from the date of breach. This arises from Section 7, subsection 5A of the Act. It is notable that whilst there is power in the court to extend the period under Section 7.5b, when it considers it equitable to do so, having regard to all the circumstances, it is also the case that, firstly, there is no equivalent position as would apply under Section 28 of the Limitation Act 1980, which benefits a child being a person under a disability by extending the period in which a claim may be brought to 6 years after the child attains a majority. The text of that Act is in Volume 9, Tab 88, SMS 9. Secondly, the case law indicates clearly that the fact that the claimant is a child is but one factor to be weighed in the balance. We see this vividly illustrated in the case of MT and the Ministry of Justice, where the Court of Appeal upheld the judge's refusal to extend time to bring the claim, notwithstanding the fact that the child was only 6 years of age. Volume 9, Tab 95, SMS 214. Thirdly, it is almost self-evidently the case that in the sphere of claims against social services for the negligent failure to intervene to protect a child would only be able to access his or her remedies speedily via an adult, such as a parent, in circumstances where the very harm from which social services have failed to protect the child may be harm threatened by that very same parent. This is a point made forcefully by CCLC in their submissions at paragraph 53, which we adopt. They are at 1318 of the supplementary memory stick. Furthermore, the basis of the assessment of damages is quite different, particularly in relation to non-pecuniary loss, and cannot, for example, include an award of exemplary or aggravated damages, a significant issue when Article 3 ill treatment may be alleged. Moreover, the monetary awards made by the Strasbourg Court are notoriously low, and as the House of Lords made clear in Greenfield and the Secretary of State from the Home Department, the Strasbourg approach to the assessment of damages was to be preferred to the one which would apply under English common law principles. The key reasoning of this is at paragraph 19 of the report, the judgment of Lord Bingham, Volume 9, Tab 101, SMS 377. Furthermore, practitioners will know that there are legal aid complications which can operate so as to see any damages awarded consequent to a claim being made as part of Children Act proceedings wholly swallowed up by the statutory charge. An example of that we see in 2017 in CZ, a Human Rights Act claim, a decision of Mr. Justice Cobb, Volume 9, Tab 93, SMS 169. It is fair to say that recently, very recently, the Legal Aid Agency have issued a practice note in which they indicated that they wouldn't seek to enforce a statutory charge in relation to a freestanding claim made by a child. But that in itself gives rise to difficulties because issues of proportionality then come into play and the difficulties arise in relation to making a claim for what might be quite a modest monetary award of damages in circumstances where the costs of claiming that might be said to outweigh the compensation sought. We therefore submit that it is strongly arguable that to deny children the right to claim common law damages against social services for the negligent performance of its duties, despite the special status accorded to the Convention Rights of Children, would be to leave them without an effective remedy in violation of Article 13.
Of course, Article 13 isn't given effect as a convention right in domestic law.
I accept that, But as we've seen in all the Strasbourg cases, Article 13 was a prominent feature of the reasoning of the Strasbourg court in coming to the conclusion that there was a very wide margin between the effectiveness of the remedy provided domestically in England and Wales, and that as a minimum standard required and expected by the Strasbourg court. And in our submission, and I'll come on to make the point, if we're looking at outcomes, and we're looking at a situation whereby the Strasbourg takes you to a place where there has to be an effective remedy, and the remedy is quite clearly defined as being one of requiring compensation for pecuniary and non-pecuniary loss, to end up at the situation that we face as a result of the Court of Appeal decision in this case is a very wide difference between the two in terms of outcome, and would fall to be accommodated, we would submit, by this court.
Was Article 13 not included in the schedule to the Act because of Section 7?
Yes.
Thank you.
The question may be asked as to why all that I've just submitted to you is why it's relevant. We submit that it's axiomatic that the courts of England and Wales are obliged to act compatibly with the Convention in all cases. We refer to Section 6 of the Act, whether or not they are brought under Section 7 and or explicitly raise human rights issues. They are further obliged to take into account any relevant Strasbourg jurisprudence under Section 2, to follow such jurisprudence where it is clear and constant. If authority is needed for that, we refer to the decision of the House of Lords in Alconbury at paragraph 26, SMS 35, tab 90. Finally, on this point, although we recognise that the natural starting point on the questions of principle to be decided in this appeal is an analysis for the extent of the common law duty in the light of the decided cases in England and Wales, any outcome which denies the existence of a duty of care would be likely to leave children with no effective remedy for having been exposed to ill treatment and abuse, a state of affairs giving rise, we would submit, to a wholesale violation of their convention rights. Finally...
Oh, you're past your time.
I'm sorry about that. May I just make two further points? Firstly, in relation to the measures to be taken by social services. We've set these out in extenso in our written case at paragraph 62. And I shan't develop those points at all. That's effectively a list of measures we said should have been considered, or could have been considered, by social services in this case, before you get near the point of asking the question as to whether or not these children should be removed in a non-consensual way. And it makes good the point that there is social services are not simply faced with a binary choice between doing nothing and proceeding immediately to an emergency protection order, interim care order approach. I must, however, just conclude by making reference to the contribution sought to be made by Article 39 the care leavers. May I just complete that? It's about 2 pages. The written case of Article 39 and the Care Leavers Association is dated the 19th of June 2018 and was therefore filed prior to and thus takes no account of the written cases of the Air Centre, Coram or the respondent. Should there be any queries arising, their counsel who are in attendance today can respond in writing to assist the court. Briefly on their behalf, I wish to make some short remarks about the interveners themselves and summarise their...
No, please don't do that. Please don't do that. Just give us the
core submissions.
2 sentences, the core submissions that they wish us to take on board. Well,
may I just deal with it in this way? Firstly, international treaties and standards, most pertinently the UNCRC and the comments of the committee of the UNCRC, confirm the particular vulnerability and powerlessness of children. Secondly, they highlight the fact that their written submissions are solely focused on the relevance of the interpretation of the international instruments to the common law. And thirdly, they make the point that given the clear international recognition of the importance of recovery, reintegration and redress for victims and survivors of child abuse, and the greater understanding which society now has of child maltreatment and its potential lifelong impact, the weight which is to be given to the competing public policy considerations now is very different to that which pertained in the 1990s. They submit that accordingly it is now clear that it is fair, just and reasonable for a local authority to owe a duty of care to a child in a child protection case. I'm most grateful for the time.
Well, I'm sorry for rushing you along,
Of course.
but I'm afraid the appellants went a little bit over time, and we have to be very careful not to deprive the respondents
I accept that entirely.
the time for which they're entitled. But thank you very much indeed. We're grateful to all the interveners, and particularly, of course, for the fact that they act pro bono, which is much appreciated. Thank you.
Yes.
My ladies, my lord, disputes between neighbours are often protracted and bitter, and the courts are only too familiar with them. They form a considerable part of MPs' constituency business. Sometimes they're concerned with boundaries or the landi or excessive noise. And they're not peculiar, such disputes, to one section of society. But in this case, there was a degree of bullying of the appellant's family which went well beyond the level of a normal neighbour dispute, if there is such a thing. The appellants and their mother were certainly very vulnerable. In failing to tackle the campaign, if one can dignify the behaviour with such a description, in this way, criticism has been levelled at the council, the police and the Poole Housing Partnership, an arm's length body to whom the council delegated much of its housing function. The appellant's family moved into Grange Gardens on the Bourne estate in May 2006. It was a cul-de-sac with 40% private owners and 60% social housing. The council, as the court has heard, provided the appellant's family with housing and spent £40,000 in adaptation so as to cater for one of the children's disabilities. The family, the H family, although I should say that their name is actually mentioned in full in the Court of Appeal judgment, but I will avoid using the full name so as to restrict the possibility of any breach of anonymity, had caused serious problems with neighbours before the appellant's family arrived, and they were known to various agencies. It seems like the H's probably concentrated their attention on the appellant's family because the mother was particularly cooperative with the police and other agencies. And the Statement of Facts and Issues sets out the sorry story of very serious harassment of the family. The H family were in fact evicted in February 2017, and they had been on the estate since 2007, I'm so sorry. They had been on the estate since 2000. However, they continued, as the court will know, to haunt the appellant's family. The mother had moved to private rented property only a quarter of a mile away. And this was, of course, outside the control of the council, who had no responsibility or power to rehouse that family because they had made themselves intentionally homeless. How could the authorities have dealt better with what not only the family but various friends and supporters appear to have done? The appellants, as the court knows, rely on a lengthy report from Maria Riga, and she's broadly critical of the response to the behaviour of the H family towards the appellant's family. In practical terms, it might be thought that the only real solution was to move the appellant's family away from the area altogether, which did finally happen in December 2011. But between 2006 and 2011, various steps were taken to try and control matters. It's interesting that there was never a reference to the Social Services Department during that period, and the reference to that contention is MS 3135. Maria Riga is specific that there were never any concerns about the appellant's mother's parenting ability per se, reference MS 3132. And criticism focuses rather on a failure to use ASBOs, highlighting agency and officer exhaustion, and pointing out a breakdown in the relationship between the ASBO coordinator and the appellant's mother. At one stage, the police were considering a police protection order, reference MS 3119. And as we make clear in our printed case, it was only actually the police who had the powers to take the appellants away from their mother without a court order to protect them, albeit this is a very limited and temporary power. There were episodes of respite care provided by the council, but they were rather more to do with the challenging role that the appellant's mother had as a carer. Not unnaturally, she struggled in the circumstances to balance the competing demands on her resources. It would not be an exaggeration to say that at times it seemed like the family were almost under siege. Maria Rigas criticises social workers for not advocating rehousing. However, she points out, and I quote, that child protection procedures are not well suited to addressing concerns that are not caused by a parent's abuse or neglect, MS 3145, and adds, quote, a child protection plan was not going to stop the H family abusing, harassing, threatening and assaulting one of the appellants and never protect him from identified harm, MS 3146. My ladies, my lords, it's clearly desirable and was desirable that the various agencies should have performed better, and in particular in a more coordinated way. But the question for the court is whether it is desirable or appropriate, or to use Lord Brown's phrase in one of the cases, a good idea, that public money should be paid in compensation to those who have been the victims of the crimes of third parties, a point made so clearly by Lord Toulson in the case of Michael. This claim is ultimately about compensation, which a public authority, if liable, will have to pay. The appellant's mother was originally a party to the litigation. The schedule of damages, very much in sketchy form, nevertheless included a substantial claim for damage to her business and a claim for the loss of the right to buy her house. Nothing by way of any detail has emerged from the appellants by way of a schedule to indicate what the scale of their losses is said to be, and it may well be there'll be claims for loss of earnings if this claim is allowed to proceed, or indeed lifetime support of some sort or another, which may be said to be attributable to the inaction of the council. My lords, my ladies, we repeat what we said in our printed case, that we very much regret the council, indeed other agencies, were not able to prevent what happened to the appellant's family, and it's no part of our case that we don't acknowledge the plight of vulnerable children. But the question for this court is whether, as a matter of law, this claim for damages in negligence should be allowed to proceed. The law has approached cases of this sort in a number of different ways, and as the courts will be aware, there have been a number of decided cases in the appellate courts as to the proper analysis of matter of law. The authorities bundle, already long enough, only represents a fraction of the occasions on which the courts have grappled with these difficult issues. The most recent examination of the law in relation to the duty of care is, of course, the case of Robinson, to which I will refer. Taken together with Michael, we submit that there is now greater clarity as to the approach to situations of this sort. I say situations of this sort because at the heart of this claim lies the question of whether there should be liability on the part of a defendant for failing to prevent the deliberate criminal activity of a third party. These failures would, we submit, be properly described as omissions, as discussed in Robinson, and would not require any caparo analysis, having regard to the clear line of authority, which we submit already covers the point in issue. There are further reasons why this appeal should be dismissed. It is in reality a claim addressed to the local authority in its housing function. There is clear authority that no common law duty arises in relation to alleged failings by the housing department of a local authority. Indeed, one of the themes of recent case law is that the fact that the defendant may be a public authority does not change the essential analysis in relation to the absence of a duty of care as regards omissions to prevent deliberate harm by a third party, what's been described by some of the academics as the equality principle. But there were, my lords and my ladies, already authorities in cases like Gorringe and Stovin and Wise that a failure by a local authority to exercise powers which they had would not ordinarily give rise to a duty of care. And then, of course, we come to the case of Exon Bedfordshire, now more than 20 years old. The House of Lords decided that the approach the courts would take to cases involving a failure to take children into care and more. In essence, we submit the allegations made in this case, however unrealistic they are for the reasons that we give in our printed case, are concerned with an alleged failure to take the appellant's children away from their mother. And whatever the effect of subsequent decisions following X, such as Barrett, Phelps, and as summarised in S and Gloucester, the allegations fall clearly within the scope of the decision in X. Sometimes, and indeed in D and East Berkshire, this has been described as the core proposition. There has been no attempt by my learned friend to suggest that X was wrongly decided. Their argument rests firmly on the basis that the Court of Appeal in D and East Berkshire had decided in a sense that the Human Rights Act had changed everything. It's our submission that the cases of Smith and Michael make it clear, as the Court of Appeal here found, that the analysis by the Court of Appeal in D and East Berkshire, notwithstanding the distinction of the constitution of that court, was not an accurate analysis of the legal effect of the Human Rights Act on the law of negligence. A substantial part of the appellant's argument is concerned with the application of the rules of analysis derived from Young and Bristol aeroplane. We set out our arguments in relation to that in our printed case, and I don't intend to elaborate much on that. We submit that the Court of Appeal was right in that regard, but in a sense it is water under the bridge.
Once you're here, it's water under the bridge.
We are now before this court, and the court will decide whether or not to follow D and East Berkshire, or to follow in the Court of Appeal, or to follow Michael and Smith. And we, of course, submit that this court is bound by X and Bedfordshire. We are not, I should say, also at issue with the interveners about the concerns they express for children and indeed for vulnerable adults and the need adequately to protect them. I will respond, I think, tomorrow in a little detail, but not much detail, about what the interveners say. But may I now turn to a few, and there won't be many of the cases which we say are critical to the analysis before this court. May I begin by asking the court to look at the case of Mitchell, which is at tab 12, Authorities Bundle 2, MS number 474.
Sorry, could you give me that number
It's
again?
MS 474.
474, thank you.
This was a decision of the House of Lords. It concerned what happened in housing in the Glasgow City Council. My Lord Reid gave an important judgment in the lower courts in Scotland, which was entirely endorsed by Lord Hope and indeed the remainder of the panel of the House of Lords. And much, if I may respectfully say so, of what he said finds an echo in the case of Robinson in terms of the analysis. Well, the facts of the case are short but quite important in terms of the analysis. And Lord Hope, and if I could ask the court to look at 4 MS page 480, summarises them. Mr. Mitchell was attacked by his next-door neighbour, Mr. Drummond. A stick or an iron bar was used in the attack and he was hit about the head and severely injured. And the claim was brought by the deceased widow and daughter. It was a claim in negligence and also under Article 2. Under the heading The Facts, letter G on that page, this is still at 480, the court summarises the fact that there was quite a long history. The facts went back a long way. And in fact, the deceased became the tenant of the property next door in March 1986. That was 6 years before the murder. And the speech of Lord Hope details the quite frequent contacts that there were between Drummond and indeed others, because he used to intimidate elderly residents, not just the deceased. We can see at letter C. Various people were involved, city councillors, even members of the Scottish Parliament. And proceedings were served on Drummond, notices of proceedings. But what was particularly relied upon on this case was that there was a meeting, which we see at letter G, MS 481, when the defenders wrote to Drummond inviting him to a meeting to be held on the 31st of July 2001. He was told there was to discuss an incident. It was an incident when he'd been confronted and had reacted in a stormy way. And he attended the meeting. He lost his temper, became abusive, and then at 3 p.m. he assaulted the deceased and caused his death. And at MS 482, at paragraph 7, it says the defenders did not warn the deceased they had summoned Drummond to the meeting that was held, nor did they make any attempt to warn him. And the case against Glasgow City Council was the simple basis of a failure to warn him.
That's right.
Because they accepted, in fact, although they had originally alleged that there was a failure to act on the repeated complaints, that could not proceed because of authority. So they appreciated that Hussein, X, and D in East Berkshire had made that impossible, including paragraph 82, to which there was reference earlier. So it was an attempt to somehow circumvent the law by relying on the failure of a duty which was said to exist to warn. We do ask the court to bear in mind that there was a long history of contact here. This wasn't just one intervention. And I take the court to MS 488, paragraph 26, where Lord Hope deals with the Caparo analysis and the fact that the defenders did not deny they owed a duty of care to their tenants in the exercise of their contractual duties as landlords. Having been accepted, this does not extend to the exercise of discretionary powers under the statute. Of course, that must be right. He then deals to paragraph 27, MS 489, with the duty to warn, and deals with the various problems about a duty to warn, and comes to the conclusion that there is no duty. And if I could take the court to his conclusion at 490, just above letter C, this is MS 490, I would conclude, therefore, that it would not be fair, just, or reasonable to hold that the defendants were under a duty to warn the deceased of the steps they were taken, that the common law case made against them is irrelevant, but also hold as a general rule that a duty to warn another person that he is at risk of loss, injury, or damage as a result of the criminal act of a third party will arise only where the person who is said to be under the duty has by his words or conduct assumed responsibility for the safety of the person who is at risk. And it wasn't suggested that the various contacts the council had somehow put them into the category of having assumed responsibility.
Perhaps I could just ask, my understanding is that the word irrelevant when dealing with Scottish proceedings has a special meaning.
Yes.
I'm correct about that, aren't I?
Yes, you are.
Yes. It doesn't mean irrelevant in the ordinary sense of the English language.
My understanding was the same, but I'm very glad to have it confirmed. And if we go to page 90, MS 500, can I take the court to just above letter F, the speech of Lord Roger? By contrast, the meeting between the local authority was preparatory to a possibly legitimate exercise of the local authority's power to recover possession of his house. And then he deals with the fact that Parliament chose to give the local authority a power to raise proceedings. It chose not to impose a duty on the local authority to raise them, so the mere creation of that statutory power cannot be regarded as imposing a common law duty to exercise that power. Stovian and Gorringe. In this case, it can readily be seen that any such duty would be inappropriate, since the local authority have to consider a whole range of factors, including the possible need to rehouse the disruptive tenant, and so perhaps replicate the difficulties elsewhere before deciding whether to take proceedings. And then he goes on to outline that further and over the page, dealing with the problems that a city council is faced in this sort of situation, competing demands. And indeed, if I might pick up the speech of my Lady Baroness Hale, which we can see at MS 504, paragraph 76, just below letter E on that page. The second point upon which we are all agreed is that foreseeability alone is not enough to impose a duty to safeguard a person from the criminal acts of third party.
That was the principal argument made
Yes.
on behalf of Mitchell.
It's a necessary but not a sufficient condition. There must be something more. In essence, there must be some particular reason why X should be held to have assumed responsibility. I also share the view of Lord Roger that this is not a pure omissions case. A driver who takes the roads is thus an actor in the drama, is liable for things which he fails to do as well as things which he does. And it could be said that the local authority were actors in the drama. My lady's expression, they took the action of summoning Mr. Drummond to warn him of what they proposed to do if he did not mend his ways. Just as the driver should not change direction without taking steps to safeguard other road users from harm, it could be said the local authority should not take action against one tenant without taking steps to safeguard his neighbours from harm. Hence, it's not quite enough to say that the complaint of a failure to warn is a complaint of pure omission. But the question remains whether it is fair, just and reasonable to impose such a safeguarding duty upon the local authority. And Lord Brown, in the next speech, MS 505, makes the important point at paragraph 79. My lord, suppose a landlord knows his disruptive tenant to be in dispute with a neighbour. Suppose further the neighbour complains and the landlord then threatens the tenant with eviction for causing nuisance and annoyance. Suppose finally the tenant blames the neighbour for this and attacks him. Is the landlord to be held liable to the neighbour or to his dependents? The answer must be the same whether the neighbour too is one of the landlord's tenants or merely another resident in the area, and the same whether the landlord is a rich public authority or a poor private owner. This is not a case about the liability of public authorities. And then at paragraph 81, he rehearses the well-known principle that generally speaking, people are not liable for the crimes of others. And at letter F at MS 506, it cannot credibly be suggested that any of the situations arise here. Those are the situations, a Dorset yacht type situation, or giving a loaded gun to an unstable police probationer. Cannot be suggested that any of these situations arrive here. Landlords are under no obligation to supervise their tenants and prevent their committing criminal acts by threatening a disruptive tenant. That, I think, is all we need from that case for our purposes. They also had to consider the Article 2 point, but that doesn't arise on our facts.
D&D Berkshire was cited, but in the House of Lords.
Yes.
And is, I think, briefly mentioned in Lord Hope's speech. But I'm not sure whether it's...
No, I think...
There's no reference to D&D Berkshire in the Court of Appeal, is there?
No, but if one picks up paragraph 84 of Lord Brown's speech, there had been the decision in Smith and Van Colley, in which, amongst other things, it had been decided, and Lord Brown really gave the leading speech on this particular aspect, that the Human Rights Act was one thing and the common law negligence was another thing, and he specifically referred to D and East Berkshire in the Court of Appeal in his analysis, which I'll take you to. So things had moved on since D and East Berkshire in terms of the relevance of the Human Rights Act. May I now take the court to another case, which is X and Hounslow, London Borough Council, which is at Authorities Bundle 5, tab 53, MS 1704. This is a decision of the Court of Appeal in 2009, the leading judgment given by Sir Anthony Clark, then Master of the Rolls. If I could take the court to 1704, the head note, the brief facts are somewhat important because claimants had learning difficulties, as did the other child, and were under supervision of the social workers from sections within the Council's Social Services Department dealing with persons with learning difficulties and child protection. What happened was that the whole family, because both the parents, as it were, and the children were highly vulnerable, were taken advantage of in the most appalling way. There was regular council involvement, but it did not prevent an appalling weekend of abuse and assault taking place. And the Court of Appeal, in allowing the appeal from the judge's decision, considered that where the local authority were merely doing what a statute required and by acting under its statutory powers, unless it had actually carried out acts or entered into relationships or undertaken specific responsibilities giving rise to the duty, it was only in such a case it was fair, just and reasonable to hold that the council owed the duty, and the instant case was not one. And nor was it a case of assumption of responsibility, unless it could properly be held there was a voluntary assumption of responsibility, that the circumstances showed that the Council's social services and housing departments were seeking to carry out their statutory duties, and no more, and no one had assumed a relevant and specific responsibility for the claimant's safety. If anyone had assumed such responsibility, it was T as the claimant, and that was dealing with a particular social worker who'd had regular contact. So there was a finding there had been no assumption of responsibility, and that was one of the arguments that was advanced in this particular case. At MS 1709, the Master of the Rolls dealt with the statutory framework, and it is, whatever else may be said about X, clearly the law that any existence or non-existence of a duty of care will be profoundly influenced by the statutory framework. Observations of Lord Brown Wilkinson, which have been repeated in a number of cases. I don't take you to that statutory framework, but of course it's relevant for our purposes as well. And if I could take the court on to 1711 under the heading The Judgment, the judge held that as a single entity, the council owed a duty of care to X and Y, and that it was in breach of that duty. He held that it ought to have moved them to temporary bed and breakfast accommodation in order to protect X and Y. He held that it was unnecessary to consider the position of each of the council's department, and then dealt with the failure of communication between departments. The Master of the Rolls referred at paragraph 24, MS 1712, to some dicta of Lord Hoffman, where he said, "We note in passing that in the O'Rourke case, the House of Lords rejected the submission that it made a difference that a local authority had acknowledged the duty by at first securing accommodation. Lord Hoffman, with whom all the other members of the appellate committee agreed, said, the concept of a duty in private law which arises only when it has been acknowledged to exist is anomalous. It means that a housing authority which accepts that it has a duty to house the applicant, but does so inadequately, will be held liable in damages. But an authority which perversely refuses to accept that it has any such duty will not. This seems to be wrong."
Could I ask you, Lord Fawkes, just looking at the head note which you read out to us, one of the points made allowing the appeal was that the local authority had not created or increased the risk to the tenants in that case, because they themselves had befriended the youths who then subjected them to terrible abuse. It might be said against you that in the present case, the local authority did create or increase the risk to the appellants by housing them next door to a family who were known to have a long history of antisocial behaviour, particularly housing a family who were by the nature of a family vulnerable to abuse.
I have one or two answers to that point, which highly pertinent point, of course, I accept.
Well, if you're going to come to it later, then...
No, I'll come to it now, if I may. The first point, of course, is that the putting of the family, as it were, next door was preeminently a housing decision. The fact that the H family had a history with agencies, which appears to be in the position, might have meant that they were a troublesome family generally towards other people, but not necessarily specifically towards this family. There was no, for example, history of animus between them. I suppose there might be cases where if you deliberately put two warring families next to each other, that might have been the case. And there was no obvious reason why they should single on them. Their vulnerability may be one thing, but that is itself not the case. And we do make the point that, a point made by my Lady Baroness Hale in the Mitchell case, that local authorities are faced with very considerable difficulties in social housing. If they, as it were, kept a troublesome family, as it were, giving them a complete freedom not to live next door to anybody, then of course they would limit the difficulties. But the placement, we submit, is not something which, any event, law says there is no duty, but we think it's unfair, we say, to criticise them. I think the criticism...
Your reply is focusing on whether they should be criticised and whether what ensued was foreseeable or not.
Yeah.
But simply as a matter of fact, did the local authorities' action not create or at least increase the risk to the appellants?
We say not in the sense of the Dorset Yacht case where you...
Yes, Dorset Yacht's exactly what's in my mind.
I thought it might be, my lord, yes. It's not a Dorset Yacht case, we respectfully submit. This is a housing case where people, as it were, are not under the control, close control as it should have been in the case of the Borstal boys in Dorset Yacht. This is a case where the local authority in its housing function is placing a particular family and investing, as we know, quite a lot of money to adapt the house, which they think is suitable for them. It turns out...
Which budget did that money come out of?
I'm not sure which budget it came out of. I could...
It will have been under the Chronically Sick and Disabled Persons Act budget. You'll be instructed if I'm wrong.
I will be instructed, and I'll endeavour to assist the court tomorrow morning.
In other words, the social services budget.
Yes. That may be right, and I can't give a categorical answer to that. Be that as it may, the position is that they were placed in the terms of the housing function of the local authority, we respectfully submit, and there is clear authority that there is no duty in that context. And indeed, the whole way in which this claim is being advanced is to, as it were, get out of the housing argument and to put this in, because there is a clear authority against there being this duty, and to shoehorn it, to use the Court of Appeal's expression, this into a social services.
I'm sure you appreciate that the reason why I'm asking about this is that because it may affect whether this is, first of all, it may affect whether one should categorise this as an omissions case or a positive act case, and secondly, if it's an omissions case, it may affect whether this case comes within one of the exceptions to do with creation of danger or having a special or assumption of responsibility.
Yes, I readily acknowledge that the courts, for example, in the context of the police, have found exceptions to the absence of a duty. We don't use the word immunity any longer. I do appreciate in your recent authority. The absence of a duty, there have been various...
Recent.
Well, it's been emphasised in recent cases, I think I should say. In any event, the police cases where they deliberately went down the wrong way, down a tunnel, or brought some particular act to the scene, could create a duty where in normal circumstances, for the reasons of Hill, Brooks, Van Colley, and all the other series of cases, there would be no duty. Yes, there was no reference, I should say, in X and Hounslow to D in East Berkshire, although it was in fact cited in argument. We just get the record of the fact that the cases were referred briefly, I should say, to in the course of the judgment, but I don't think anything illuminates the case from the court of what the Court of Appeal said. But can I, finally, when referring to this case, take the court to 1723, MS 1723. paragraph 59, in the Mitchell case, it was common ground that the alleged duty was not part of the council's contractual duties as a landlord, which it accepted did not extend to the exercise of discretionary powers. Stated by Lord Hope, the question was whether acknowledging the council the deceased landlord was fair, just and reasonable warning was a matter of fairness. The answer was no. Paragraph 60, in these circumstances, as we see it, the question is whether this case falls within Lord Hoffman's category of cases in which public authorities have actually done acts or entered into relationships or undertaken responsibilities which give rise to a common duty of care. Examples of such cases are given in Mitchell case. Only in such a case would it be fair, just and reasonable. This is not a case of control like Dorset Yacht, nor is it a case where the defender has created or increased the danger to the claimants. It's not a case of assumption of responsibility unless it can properly be held there was a voluntary assumption of responsibility. This is because, as the cases cited above show, a public authority will not be held to have assumed a common law duty merely by doing what the statute requires it or has power to do, at any rate, unless the duty arises out of the relationship, such as a doctor-patient relationship. And then application to the facts, paragraph 61. The council's cases, this falls within none of the categories of the case discussed in Mitchell, no assumption on the facts of the instant case, and the claimant's case is in truth no more that the council failed to move them to temporary accommodation in breach of its statutory duty in the exercise of its statutory powers. We accept that submission. If that is indeed the only case that can be advanced against the council, the cases to which we have referred lead to the conclusion that because of none of the statutory provisions relied upon gives rise to a private law cause of action for breach of statutory duty or for a failure to exercise its statutory powers. And then the conclusion we see at paragraph 103, MS 1737, where the court says, whilst this has been a very troubling case, and every sympathy for the claimants in being subjected to an appalling ordeal, and we fully appreciate the judge's treatment of the matter, our conclusion is the council did not assume a responsibility to the claimants at common law, and neither its employees owed them a duty of care. In any event, neither its employees was in breach of duty to take reasonable care. Well, that's a question of fact, which of course doesn't arise here.
Does that feel like a suitable moment, Lord Fawkes?
I have 4 very short submissions, which I summarise from those 2 cases, which I think I can do in 2 minutes, if I may. We say there is no duty of care on the established principles. Hussein, and I'm getting this from these 2 cases in particular, the duty to warn did not get round that in Mitchell. Exon Hounslow was dealing with vulnerable claimants, not just children. There was no duty held there based on assumption of responsibility. Setting up a meeting and not telling the victim in Mitchell, or arrangement by the social worker of various meetings in X and Y, did not alter the principle of no duty of care in the case of an omission to prevent the acts of a third party. And finally, it is our submission that those principles are of themselves enough, taken together with Robertson, to dispose of this appeal. And that, if it appears to the court, would be a convenient moment.
Yes, thank you very much indeed. We will look forward to hearing from you further tomorrow morning at 10:30. Court is now adjourned.